ICE is now authorized to fast-track deportations. What does this mean? Hello, everyone. This is Andre McKinney-Dorval, licensed immigration attorney located in Florida. In this video, we are discussing fast-track deportations, also known as expedited removal or expanded expedited removal. Now, I am going to share my screen. We are going to take a look at DHS Secretary Huffman's memo on the subject of fast-track deportations. Now, a brief recap. Back on January 20th, the president signed several executive orders. The one order in question, Secure Our Borders, did several things. It authorized detention, apprehension, and removal of non-citizens. It ended the CBP-1 application. It also ended the parole program for Cubans, Nicaraguans, Haitians, and Venezuelans. Now, following the president's executive order on January 21st, there was a notice issued entitled Designating Aliens for Expedited Removal. That notice expands the scope of expedited removal to the statutory maximum under 8 U.S.C. 1225 sub B sub 1, which includes certain aliens who have not been continuously present in the United States for 2 years. Now, this guidance, which is issued by DHS Secretary, it explains to immigration officers how do they apply this new expanded or fast-track deportation. Now, here in subsection 1, it says, for any alien DHS is aware of who is amenable to expedited removal, but to whom expedited removal has not been applied, take all steps to review the alien's case and consider exercising your enforcement discretion whether to apply expedited removal. This include steps to terminate any ongoing removal proceeding and or any active parole status. So this section here basically sets the stage for immigration officers to look at a non-citizen's file and determine whether to end any ongoing removal proceedings if there is one, and also to terminate any active parole status. Now, this subsection 2, before we dive in, many individuals have been paroled into the country through the use of the CBP-1 application, and therefore are here less than 2 years. Such an individual would fall under this discretionary review under subsection 1. Now, let's move on to subsection 2. For any alien DHS is aware of who does not meet the conditions described in subsection 1, but has been granted parole under a policy that may be paused, modified, or terminated immediately under the January 20th memorandum. This January 20th memorandum is referring to the executive order that President Trump signed. And with regards to this section, DHS officers can take all steps necessary to review the alien's case and consider, in exercising enforcement discretion, whether any such alien should be placed in removal proceedings, and review the alien's parole status to determine, in exercising your enforcement discretion, whether parole remains appropriate in light of any changed legal or factual circumstances. So in this subsection 2, for individuals who entered on parole, who have been here 2 years or more, many individuals who entered on parole have met their 2-year mark. Many others will be coming up on 2 years when the parole is going to end. Immigration officers under this subsection 2, they are to review the alien's case and consider in their enforcement discretion whether to place that individual in removal proceedings. And so this particular memo really is going to be looking at each person's case on a case-by-case basis. Further down in the memo, it does say and direct the immigration officers to maximize efficiency in the short term. DHS components may wish to prioritize aliens eligible for expedited removal who fail to apply for asylum within the statutory deadline. So this last sentence here, guys, basically DHS officers, when they're looking at this expanded expedited removal, they can consider to prioritize which non-citizens to place in expedited removal based on who has failed to apply for asylum within the statutory deadline. The statutory deadline is 1 year from the date of entry for you to timely be able to apply for asylum. Guys, I do want to share one more document with you, and that is, we know that there have been many lawsuits filed based on several of President Donald Trump's executive orders. The Secure Your Border is no different. Make the Road New York has filed a lawsuit on January 22nd. They have filed a lawsuit naming, of course, the acting secretary of DHS. The lawsuit is still pending. There hasn't been any orders issued by the judge. We will keep you updated on the status of what happens with regards to the lawsuit. Now, guys, if any of you fall within the scope of the memo issued by the DHS secretary regarding parole, please speak to an immigration attorney. I do want to thank you for watching the video. Please be sure to like, share, and subscribe, and I will see you in the next one. Bye-bye.